ready for trial?
Yes, sir.
Good afternoon, Your Honor. Ronald Cantor. I am appearing on behalf of defendant Northland Group. I have my associate Bradley Cantor here with me. There are two motions that were filed that, according to the judiciary's website, printout from this morning, it says they were attached to be ruled upon by the trial judge.
Okay.
The motions are as follows.
All right, hold on for 1 second. And are you Mr. Wesselberger?
Yes.
Am I saying that correctly?
Yes, sir. And I haven't had a chance, Mr. Cantor's going to speak about the motion. I haven't had a chance to review it and got it, so I'll make an oral motion or oral opposition. I haven't had a chance to.
Okay, sure. Okay, absolutely. You can, whoever is not talking can have a seat. Okay.
Your Honor, the docket shows that on March 6th, Mr. Wetzelberger filed what is noted in the docket as an interlineation claim amendment. We moved to strike that amended claim on the basis that Rule 341B provides that if you amend, you can only amend within 15 days of the trial date if the other party consents or by leave of court. So there was no leave of court. We did not consent. We moved to strike that amended nature of action. We also moved to strike the interrogatories, which the docket shows were noted and served on March 6th for two reasons. This is a small claim. There are no discovery in small claims. And the second is that even if it was a large claim, the interrogatories were not timely served. They weren't served within the period required by Rule 421B, which requires service 10 days after notice of defense is filed.
Okay.
But we are prepared to proceed. I'm prepared to represent the defendant and in this case, based on the original claim.
Okay. Mr. Wesselberger, you want to respond to the motion?
Sure, Your Honor. Have you had a chance to look at the docket and familiar with the case at all? Okay, cool. The original case, as Mr. Tanner said, was a small claims case, and the defendant never answered. And I think how it works here in small claims is there's an affidavit judgment that's entered if no one answers, come to trial, and there was no answer. So I showed up at the trial date about a month ago.
Well, that's not entirely true. The rule says an affidavit judgment may be entered. It's not required.
Fair enough. So I saw an affidavit judgment was not entered instead of the trial. And I said, well, you can't get discovery in small claims. So I thought I read, I may have been mistaken, I thought I read the rule correctly. If you amend the complaint within 15 years, Mr. Tanner said, you can't get discovery in small claims, but you can, above 5,000. That's why I amended the complaint. I'm pretty sure I served it timely with the interrogatories.
And when did you amend the complaint? I
amended it right at that 15 days when I saw the affidavit judgment was not entered. So if, in the alternative, if that's not, I believe so, yes, sir. If that's not allowed, I'd rather voluntarily withdraw the case and just refile it as a case and district court type of discovery.
Well, the problem with that, I mean, I'm happy to let you withdraw the case, but a notice of intention of defendant has been filed. That means that if you voluntarily dismiss the case, unless Mr. Cantor consents, your dismissal will be with prejudice.
Got it, and fair enough. And I'm trying to understand the flow here because I'm pretty sure I think there's no appeals from the small claims.
That's not true.
Oh, okay.
There are appeals from small
Okay, thank you. I misread the rule.
They're de novo appeals. They're not on the record.
Fair enough. If there's an appeal, I thought I read it wrong. You couldn't do an appeal. That's why. So if there's an appeal from the small claims, I'm prepared to go forward with them as well.
Okay.
And I oppose those motions, but it's your choice whether you think they're timely or not, or they want.
Okay. I don't think they were timely. I'm going to grant the motion. So we're going to proceed to trial on the original complaint, and I will not make any order with regard to interrogatories because I don't think they're on the trial.
Sure. And that's one question. So that I'm giving on the witness, obviously, on the plaintiff is giving testimony. Do I just get sworn in now, or just when I come to give any kind of testimony? Because I don't know if you want all the testimony.
I'll let you know.
Okay.
But it'll be right before you testify. But just want a couple more things before we get to that. Okay.
Sure.
Okay. So any other outstanding motions?
No.
From Mr. Wesselberger? Okay. Anything preliminary, stipulations, exhibits that are stipulated to, or anyone want to make an opening statement?
I'm fine with letting the court hear the case of small claims matter.
Okay.
Same here. Yes, sir. No.
Everybody who's going to testify, stand up and raise your right hand.
You solemnly swear or affirm under the penalty of perjury that the responses given in the statements made will be the whole truth and nothing but the truth. State your name for the record, please.
Todd Wesselberger.
Mr. Wesselberger, it's a small claim, so you can just have a seat right there with your paperwork, and you can tell me why you think the defendant owes so much.
If you, I know you have other trials here.
Well, let me help you.
Sure,
Whatever you filed isn't evidence.
understood.
So whatever evidence you want me to consider, you either have to tell me or introduce subject to Mr. Cantor's objection.
Understood, thank you. I'm just trying to be efficient with the time, I know you have
That's all right.
The complaint speaks for itself. Essentially, you said I'm going to stand up to small claims.
No,
Okay.
consider it.
Essentially, the quick background on this, you've already read the complaint. Northland sent a demand, I think about a year ago.
Okay, I'm sorry to interrupt you one more time. I really want to be fair to you. This is the last time I can tell you. I really can't help you try your case.
I was given, I thought it was an opening statement, I'm sorry.
No, this is testimony.
Okay,
Your complaint is not evidence.
got it,
So prove your case as if this is a blank slate,
understood.
okay?
Okay,
Because sometimes it is.
got it, thank you. The exhibits to the complaint will prove that Northland made an initial demand for money. A notice of demand was made to Northland to prove that claim 4 different times. In each exhibit, evidence of that. Northland did not answer any of those notice of demands. They did also not answer a notice of intent to sue. So after 5 opportunities, I was left with no choice but to file the complaint for the 4 causes of action. The complaint was filed. In my opinion, the exhibits speak for themselves. They evidence that chronology right there, that Northland never answered a demand for proof of claim. They have not answered the complaint itself. And as I said before, if the affidavit judgment would have been entered, this would be over. But in my opinion, in my testimony, the intention to defend was filed after the fact. It was not filed timely. So, in my opinion, the evidence here, the 4 exhibits with the complaint, shows that I'm entitled to judgment based on the causes of action, and the exhibits are fairly clear. So, the period of, I guess Mr. Tanner's going to either object to each one of those, but I'd like to move all 4 of those. All 4 of those, okay. I'd like to move all 4 of those exhibits into
Why
evidence.
don't you do this? Why don't you briefly describe to me what the first one is? Don't
Sure.
have to read it or anything.
Sure.
Describe it.
Hang on 1 sec here.
I trust you, Dale, will help you show it to Mr. Cantor.
Sure.
I have copies as long as I can make sure that they're the
Okay.
same.
Sure, and I take it these here, I've already got these marked, exhibit 1, but you need these for the file?
I don't need them because this is a small claim. After it's over, I'm giving everyone their exhibits back because the next trial is what we call de novo or all over.
This is first time for me, thank you. Exhibit 1 is the initial demand letter from Northland Group. That's what the judge.
Small claims, Your Honor, no objection.
All right, it's admitted.
Exhibit 2 is the credit inquiry from Northland Group on the credit report, which supports one of the causes of action for violating the Fair Credit Reporting Act. This is evidence of that inquiry into the credit report. I think it's cause of action.
It's admitted without objection.
Yeah, I think that's the cause of action before. Exhibit 3, Plaintiff's Exhibit 3, is the notice and demand letter from March 1, 2013. Pages here that made the demand on Northland to prove their claim. And this was never answered by Northland. It was sent to John M. Johnson, the CEO of Northland Group, and sent by certified mail, and I have proof of them receiving that. Exhibit 3.
All right.
Oh, here you go. Yeah, that's another, that's a proof of the last page of that.
The court results for a moment. I just want to match them up with what I've got. Well, that's part of it. No objection.
Admitted without objection.
And the last one here, this is Appendix A. It was an appendix to the complaint. This is a case, another case of another consumer, Roberta Fox, versus Northland Group in Alabama. And I understand it's not a Maryland case, but this case, Roberta Fox versus Northland, evidences the pattern of Northland making thousands of claims across the country, and their model is they have no intent of proving their claim. They operate on a model of 90 to 95% default, and the few that actually respond, Northland oftentimes doesn't even respond to the complaint against them, and that is essentially, until today, that's what happened in this very case. So this Appendix A is material because it essentially is evidence of the pattern that happened in this very case. So this is Appendix A, which is the case Roberta Fox versus Northland and NDN funding.
My objection is based on the fact that a claim in another state by another party is not relevant to this claim that you're making. Okay?
I'm going to admit over your objection. I don't think it goes to its weight and not to its extent. So it'll.
I've seen, yeah, thanks a lot.
Thank you.
And that's all I have for exhibits moving evidence. And I think at this point the exhibits speak for themselves. And I'm trying to think if I have any other relevant testimony. I think the docket speaks for itself. I have personal first-hand knowledge of these facts. I'm the one that got the demand. I'm the one that mailed the demand to Northland. I personally mailed all of these demand letters. So I have personal first-hand knowledge here of all the material facts. And the last thing on the record here is it's obvious to the court that Northland has no witness to rebut my testimony, or impeach it, I think that's the word. And that's all I have to, I think it's all I have to offer.
Okay. Mr. Cantor may have some questions.
Thank you. Mr. Wettenberger, in your notice to agent, you said in paragraph 12, you wish to resolve this matter at the earliest possible time to avoid the cost of protracted litigation, correct?
I don't have it in front of me, correct. That's the one I just handed up to him, correct.
But you haven't been sued by Northland on this debt, have you?
I have not been sued, but an attempt was made to collect the debt from me.
Correct.
But not debtor.
And then you told them you disputed it, correct?
Correct.
And the next thing that happened is you sued them.
There's, if I can look correctly, I'm trying to be factual. There's an intermediate step. There was a pro forma complaint and a notice of intent to sue before the complaint was filed. And every, just to be clear, and the judge heard this, every attempt to try to resolve this was never answered. Not a phone call, not a letter, we have representation. There was never any response on 5 different occasions. So I feel like I acted in good faith to do my best to resolve this. And there's damage to the credit report. I mean, the damage to the credit score. I'm a real estate developer, and it's like a carpenter and his hammer. That's very important to me. And I feel like I made good faith efforts to resolve this, and no one ever answered until now. This is the first time, so it could have been resolved earlier, I believe.
The efforts to resolve it would be for you to pay what would be established you owed?
Are you making testimony that there's an amount due owing to Northland Group?
No, I'm
asking
asking
you a question.
Do you have any evidence there's any money doing to Northland Group? That was the point of the demand letter.
I'm asking you whether or not what you meant was your efforts to settle what could be established you owed.
The efforts to settle this was for Northland to prove there's a dollar amount owing, who it's owed to, and produce a bona fide claim with strict proof.
So you don't know any. It's your testimony today that you don't know how this debt was created. You don't know what was purchased.
Exactly. That, and just to be clear, if you're familiar with the case, you read the demand letter to Northland, it very clearly articulated in that demand letter all these questions you're asking you would already know about if you would have read it. I don't mean to be smart, but I've already covered this with Northland over a year ago. They never responded.
And they claimed you had a debt, but you said, I don't owe it, so I want you to prove it.
Exactly.
Okay. And therefore, you have no idea whether what was incurred was, for example, for a real estate investment or for groceries, do you?
It's a great question. Glad you asked it. We have a lot of trade accounts. We have hundreds of trade accounts at real estate development business. If I see something pop up in the credit report, I'm not sure what it is, and this is material. I have another case that hasn't been filed here yet. That city, we have a lot of real estate property mortgage. Here's an example. The answer to your question is yes, but I want to expound on it. I have a zero balance from city mortgage for like $137,000 loan from city 2007. 2007 was paid off. An attorney, I'm not going to mention his name on the record, an attorney went and filed a case a year later in this very court claiming there was a balance due owing. A year later said, I got a zero balance. This happens very, very often in debt collector business, especially when certain debt collectors work with certain banks to try to collect on a debt. They buy bulk debts, they don't even verify them. And that's the whole point of this. It's not verified, Mr. Cantor. I know you came in last minute, but this has not been verified. That was the whole point of all this over the last year.
So they asked you to pay, you said it's not verified, and you didn't pay, correct?
Correct. Well, and I assume you're presuming there's an amount due owing.
No, I know.
Correct. Sure.
I have no further questions.
Okay. Anything else?
No, sir.
Okay. Has it explained?
Yes, I mean, I do want to say one thing for the record, although I guess you can make closing first. I do want to point out on the Court Judiciary website, on the 11th of October, the clerk made a notice that the return receipt on the certified mail was signed by another. And nonetheless, it was pulled for affidavit judgment. Now, the affidavit judgment says denied, reason for denial, insufficient documents. When we got notice of that, I entered my appearance, but the court docket had showed prior thereto that there was not valid service. So I don't think this was in a default situation. Now I understand it's not. I mean, I'm prepared to make closing after the plaintiff closes to explain why I don't believe my
Okay,
client.
so you don't have any evidence?
I don't have any evidence. I'm sorry. Yeah, that was a long way of saying I don't have any evidence.
All right, so that's the close of all the evidence in the case. So now where we are is closing argument, and I'll be happy to hear from you, Mr. Wesselman.
Sure. In a nutshell, this Northland case is essentially part of a bigger phenomenon going across the country where there are, and I'm not saying Northland's a junk debt buyer, but there are junk debt buyers that buy massive accounts. Matter of fact, there's a class, and I'll be very brief, there's a class action suit in New York for junk debt buyers. We got thousands of default judgments, and people were never even served. It's called SOAR service. I'm guessing you all heard of that. And
You can assume that while I am often a blank slate, sitting on this court, I do know a little bit about.
well, that's what I meant. I meant to say it more in general. In this case, when I've learned over the years, if somebody says I owe them money, because we've had people fraud us, I can't tell you, in real estate, we've had all kinds of issues to deal with. Somebody says I owe you money, prove it, real simple. Because I've been a lender, I've had to foreclose on properties, I've made loans to people, and I've had a bona fide agreement. I've got the books and records to prove it. That's all. It's real simple. If you have the books and records, prove it. If you don't, you don't. And I feel like I was very clear. I gave multiple opportunities to prove your claim, and you never answered until I wouldn't have filed this case, but I can't let this sit, and then until my hands are tied. So, in my opinion, the evidence, the good faith attempts to prove the claim was ignored by Northland Group, and that appendix shows, the appendix to the complaint shows the bigger pattern of Northland operates like this across the country, and somebody like me who said, prove your claim, they don't bother answering until we're here in front of the courtroom right now. So I feel the evidence and the complaints speak for themselves. I'm due and owing the damages that were caused by violation of 4 causes of action, 2 federal and 2 state, and they're pretty much similar causes of action. They have similar language. And I have no more to add.
Thank you, Your Honor. I don't think there's been any evidence to establish a violation of any statute. To the extent that Mr. Wetzelberger says he doesn't know the debt, that he hasn't been sued for it. And the court can't declare there be no debt because that would have to be a circuit court or a declaratory judgment. I do have some experience in these federal and state consumer protection defenses. Most of them are filed in federal court, but he's filed in state court. I point out a couple of things, and in terms of evidence, even though we're small claims, I do think this is significant. A claim under the Fair Debt Collection Practices Act is premised on the establishment that the collector was attempting to pursue a consumer debt. Mr. Wetzelberger doesn't know what this debt was. He candidly said, there's some cases where he's involved in real estate investment. That's not consumer debt. There's an interesting case that was decided by the Fourth Circuit a couple of years ago called, and I've got the site here, it's 462 Fed App, Appendix 331. It's unreported, but the court allows those cases to be cited for persuasive authority. And what happened was, in that case, a plaintiff in Virginia filed suit against I think it was a law firm. And when he was deposed, he said, I don't know what the charge is for. I don't know what it's for. So when it went to summary judgment, the court said, you can't establish that first element. He said he hasn't done anything to establish that he's a consumer. I mean, he doesn't know what the debt is about, and he said he does have transactions in real estate. So I think as a matter of proof, that is a sufficient defense. Secondly, he hasn't articulated what his damages are. I mean, there's simply no evidence, no testimony. Well, how was he damaged? What was done? So I think for those 2 reasons, I respectfully ask the court to enter judgment for the defendant based on A, failure to establish the prima facie element, that this was in connection with the consumer transaction, and secondly, even if it was, there's just been no articulation of what type of damages are.
Thank you. Mr. Wesselberger, you get the last word.
Thank you. With regard to damages, like I said before, maybe I didn't articulate specifically, but my reputation, my name, credit report, all of that is part of what I do as a real estate investor. And with, I don't know, you probably aware of this, inquiries on a credit report reduce that credit score to a certain numbers, especially a hard pull like that. And I was very specific about a hard pull as opposed to a soft pull on the credit report. And when we're doing different deals and stuff, if you drop below, it's like 680, 690, your credit score drops below a certain amount, you can't get financing, like usually Alt-A or no-doc loans or partial doc loans, and that directly affects the credit score. It's like, that's like a hammer to a carpenter. The credit score is everything. The banker looks at it and says, you know what, credit score is below this, can't help you out, sorry, get it back up. And sometimes it takes months and months and months to get just an inquiry like this. It should have never been made in the first place. And to this day, I don't know why Northland even made a claim on a credit report. Anyway, I didn't give them permission to do that. And that's one of the damages to my reputation and character. But it's also, I think the damages are articulated here in the time spent on this. And I don't know if it's business or consumer they're claiming, but I said in here, I assume they're trying to collect a consumer debt. And the damages to me are, I'm not going to use emotional distress. There's no pain and suffering in a car accident, but I spent a lot of time on this. As you can see, it's a well-researched complaint for small claims, and I'm not a lot of time, a lot of effort, and that I can be spending on productive activities. And that's where I feel I've articulated my damages per the four causes of action. Thank you.
Thank you. Okay, this is a complaint filed for violations of various provisions of the American Consumer Debt Protection Act. I think Mr. Wesselberger said in his final close that he agrees that he doesn't know whether this is a consumer debt or not. And because of that, those provisions of the act under which he seeks judgment do not apply. Secondly, while he did introduce evidence of an inquiry on his credit report, I don't know what effect that had on his credit report. Because there was no evidence introduced to that. So I don't think that Mr. Wesselberger has proven any damages in this case. It strikes me that it may be that here, and this is what I find the evidence to be, at least in this case, that's been proven to me, that if demand was made for payment or an offer of settlement, whatever way you want to put it, but there was a demand made, say, you owe us some money. Mr. Wesselberger wrote back and in a very articulate and thorough way said, and then maybe they said, you know what, this guy writes a mean letter, we're not going after him anymore. I don't know. Maybe they went back and said, you know what, maybe we can't prove this. Or maybe they went back and said, we don't have the documents, maybe we're not going to pursue this. But that's sort of where it ended. So I don't know what the damages would be from that. So for all of those reasons, I'm going to enter judgment in favor of the defendant. I'm going to return your documents to you. As I said, if there is an appeal, it's de novo. You'll need those for the next one.
30 days, Your Honor, I'm assuming?
Yes, sir. 30 days to go to the appeal.
Thank you.
Thank you.
Thank you, Your Honor. May we be excused?
Sure. All right, come on. Are you